right, good morning, everyone. Welcome to the Connecticut Supreme Court. Thank you all for coming. This is our state's highest court. In Connecticut, we have a three-tiered court system. We have the Superior Court, where all of our trials happen. Then we have an intermediate appellate court, and then the Supreme Court. This is our highest court. It's also called the court of last resort. This is your last chance to get the answer you want to whatever case or question that you have. This building is over 100 years old. Everything that's in here, the Supreme Court, the State Library, and the Museum of Connecticut History, used to be housed in the state capitol. Around the turn of the last century, because of overcrowding, they commissioned this building. The architect's name was Don Barber, and he built this building in the Beaux-Arts classical style. Typical of that style are all the big marble steps coming up to the building, the columns, the high ceilings. And the reason this building was designed this way was to show us that important things happen in this room and in this building. The groundbreaking happened in 1908. The cornerstone was laid in 1909, and the building opened in 1910. Most of the workers were Italian immigrants. They were familiar with this kind of construction. The Beaux-Arts style is not something we see a lot of here. And so when they were building the building, they got a bunch of people who were familiar with this kind of architecture. And so the Italian immigrants built this building in about 2 years without the help of any modern machinery. Every one of the 7 million granite bricks was put in place by hand using pulley and lever systems. All of the materials that went into building this building were brought here on horse-drawn wagons, or anything that was brought from overseas was brought here on ships. So for $1.4 million, like I said, we have 7 million granite bricks, a lot of marble. We have the lobby is pink marble from Tennessee, and the stairways are marble from Genoa and Tavernale, Italy. There's also a lot of gold. The lamps and chandeliers are gold. And the other major construction material is the wood. And if you guys will notice, it's all the same color, it's all the same kind of wood, and it all comes from our state tree. Does anyone know what our state tree is? Yes, the white oak tree. So, as I said, $1.4 million 100 years ago to build this building. If we were to do it now, it would cost us over $100 million. And it probably wouldn't be done in 2 years, and they would have the use of modern machinery. Our architect, Don Barber, had 2 friends that he also got jobs working on this building. The first one was a man named Francois Tonetti, and he was a sculptor. And he did those 4 figures. I don't know if you saw them. Out front, there are columns. Each one weighs 25 tons and was brought here on horse-drawn wagon from Barre, Vermont. Atop those columns, we have 4 figures, and they stand for art, science, history, and justice. Now, Mr. Tonetti came into Hartford, and he picked 4 state employees and used them as his model for those 4 figures. There was a third friend that got a job here, and he was a painter by the name of Albert Herder. He was fairly famous at the time, not someone we know now, but he had enough pull that he kind of bartered with the state. You can come on in. The state, as I said, had already spent $1.4 million on this building. And so they wanted one piece of artwork to finish this beautiful room. And so they had commissioned that mural on the back wall. And the artist, like I said, he was pretty famous at the time. So he put up a fight. And he said, I want to paint 2 murals for you. And the state said, we already spent all this money. We can't do it. Only the one. He said, let me explain to you. Let me tell you this story. And he ended up getting his way. And we ended up with 2 murals. So the one on the back that had been commissioned, as well as the one on the ceiling. So the one on the back wall that the state had wanted is called the Fundamental Orders 1638-1639. And what it shows is the men of our state, colony at the time, coming together to write our fundamental orders, which were the basis for our Constitution, as well as the U.S. Constitution. We have some pretty important Connecticut figures in this picture. Out front with his hands outstretched is Thomas Hooker. He was a lead theologian at the time, and he was the one who gave a sermon. He gave a talk to his friends to say, we can govern ourselves. We're smart men. We can agree on a set of rules that we're all going to follow. The rest of the men agreed, and they went on to write our fundamental orders. It actually ended up being the first written set of laws agreed upon by the men that they were going to govern. We have sitting at the table with his head on his hand, Roger Ludlow. He was the group's secretary and the one that we believe actually wrote the orders. At the time, in the 1630s, he was the only attorney in the whole colony. So we believe he's the one who had to have actually written the orders. Out front, holding the scroll in one hand, the orders, and his hat in his other hand, is John Haynes. He was our state's first governor. So this was the mural that the state had commissioned, and the artist insisted on painting the second one, which is an allegory of education. Do you guys know what an allegory is? Do you know? No? An allegory is a story, and it uses fictional characters to teach us about a real theme or idea. And so this one teaches us about education. And it shows a woman who's reading to and teaching a young boy from the book of knowledge. They're guarded over by the figures of progress and wisdom. And we have 2 spirits who are passing down the light of learning, which is chasing away ignorance and superstition. Those are those 2 guys down in the shady area. And the reason that the artist insisted on painting both the murals was to show that our justices here make their decisions based on the laws given to us by men like this, but their understanding of the laws, their interpretation of the laws, comes from their education, from all that they've learned from the books that they've read, from their families and their teachers. Another piece of artwork that we have in this room are the portraits of our retired Chief Justices. In Connecticut, we have a mandatory retirement age of 70 for all of our judges and justices. And like I said, we have those 3 levels. On the Superior Court, when judges turn 70, they can continue working as judge trial referees. And they can hear cases on a per diem basis. That means day by day. So not every day, but whenever they need to. If the state needs some help, they can work. On the appellate court, when those judges hit 70, they can continue on the appellate court, or they can return to the Superior Court. On the Supreme Court up here, once they hit 70, they can no longer hear cases here. They can hear cases on the appellate court or on the Superior Court. So as you guys see, we have 7 justices on this court. The one who sits in that middle chair is our Chief Justice. And when the Chief Justice hits 70, he or she gets a portrait commissioned, and it gets hung in this room. We have 2 important portraits that I want to point out. Up top here is Justice Raymond Baldwin. If you guys had noticed, if you had gone into the museum is actually named after him. He's the only person in our state's history to have been governor, chief justice, and senator. So he held high-ranking positions in all three branches of government. I also like to point out Chief Justice Peters over here above the clock. She was our state's first female Chief Justice, and she was appointed by our first female governor, who was Ella Grasso. Now, something else interesting about Chief Justice Peters is that she was not a judge on a lower court before being appointed here. She was a professor. She taught law at Yale Law School and was considered to be so brilliant that she didn't need the experience of working on the trial court. She already knew the law inside and out, and she could come here and do a good job, and she did. Currently, we have our second female Chief Justice Rogers, and she was appointed by our second female governor, Jody Rell. Now, Chief Justice Rogers, she's got some time under her belt. She's been here since 2007, and she will be here until, I believe, 2026. And when she retires, her portrait will get painted, and it will be hung in this position over here where Chief Justice Sullivan is. Every single one of these portraits will get moved one spot to the left. Chief Justice Wine over here will be removed from the wall and hung somewhere else in the building. So another interesting feature of this room that you'll notice is that we have our state seal on almost everything in the room. It's on the back of these chairs in the front. It's on all of the paneling. It's on the rug. We have it, of course, on our flag and on the murals. So our state seal has our state motto, Qui transtulit sustanet, which is Latin, and it means he who transplanted still sustains. We were told many years ago by a state librarian that the reason that's our state motto is that it's an interpretation of Psalm 80, I believe, from the Bible, which said, he who has transplanted the vines out of Egypt. So the idea is that the colonists, the people who settled here, were a religious people, and they believed that God had given them the impetus to move here, and that he would continue to sustain them, which means they would continue to live and thrive once they got here. Now we have 3 grapevines on the seal, and those 3 grapevines stand for our first 3 towns. Do you guys know what those are? Wethersfield? Windsor? How about my girls in the back? Any idea? One more.
Bridgewood? Girls.
No.
Girls, sorry.
Oh, that's okay. All right, we're in the last one. Hartford. All right. So those grapevines stand for our first 3 towns, and they're also used because that psalm talks about the vines. They are a native plant. They would have been here when the colonists first got here, and they could have eaten those grapes and used them to sustain themselves. And they're also a plant that can be transplanted. So you can't do this with everything, but with grapevines, you can dig them up, plant them somewhere else, and if you have sunlight and water, they will continue to grow. Lastly, we talk about all of the doors that are in this room. So our courts in Connecticut are open to the public. You guys are sitting in the public seating section. Anytime that the court is in session, the residents of Connecticut or anyone else could come in, sit in those seats, and watch the arguments. You all came in through the public entranceway, and there's 2 other doors in the room. This door over here leads out to our attorney conference room. So when the attorneys arguing a case are here, they can go into that room, get themselves ready for their arguments for the day, go over any last-minute adjustments they need to make, things like that. And then we have the justices' door in the back. So the justices come in and out of that door, and they do everything based on seniority. The Chief Justice comes out first, and she sits right in that middle seat. And then from her right to her left, alternating out, the most senior justices sit closest to her, the ones who've been here the longest, and the newest justices sit farthest away. And so then when they're finished, they'll go back out through that door and they take a vote. Now, they do this by seniority as well. The newest justices, the ones who've been here the least amount of time, vote first. And then the Chief Justice votes last. Now, her vote's not worth any more than anyone else's. All 7 justices have the same weight to their vote, but she gets to assign homework. She's the one who decides which person in the majority is going to write the opinion, which is going to tell everyone which side was the winner, what side they agreed with. Now, they hear cases here the same months that kids are in school. They start in September and they finish up in May. They hear cases for 2 weeks, and then they have a 3-week break where they're reading, writing, researching, finishing up things that they had heard in the previous term, and getting ready for everything they're going to hear in the next term. So they're on 2 weeks, off 3 weeks from September to May. They take June and July to try and finish up any loose ends that they have, write any opinions that are left, and then they try and take August off. That's really their chance to get vacation. When our Chief Justice came, she had decided that they were going to start hearing cases en banc, which means in a panel of all 7 of them. Previously, they had heard cases, sometimes only 5 would hear them. Only the very most serious cases got all 7. But they had decided that when they speak with the voice of the court, that it was only fair to have all 7 present whenever they could. Now, this kind of takes away the opportunity for an attorney to say, well, we got the luck of the draw. If we had a different panel, we could have gotten a different answer. Now, what happens here is not a trial like you guys would see on TV. There's not a criminal defendant standing in shackles. They argue matters of law here. So a trial has already happened, and one side thinks that something didn't go right. There was a mistake. Perhaps a judge didn't give the right instructions to a jury before they made their decision. Or a police officer should have read someone their rights right away, and they waited until after that person started talking. Those kinds of errors in law are what get brought here. Now, there are some cases that come here automatically. If a criminal defendant gets 20 years or more in prison, that case comes here right away as soon as it's appealed. It does not go to the intermediate court. Cases of election law come here right away. Cases of law that have not previously been decided come here right away. Otherwise, they have what's called discretion. They can decide if they want to hear a case or if they're going to send it to the appellate court and have them start with it. Do you guys have any questions? No? Oh, the last case heard here. I don't know. They hear about 140 cases a year. They hear them, like I said, those 2 weeks, and they hear about 2 cases every morning. The cases are an hour long, the arguments, and each side gets 30 minutes. If you guys will look at that podium, is normally out front in the middle of this table, and there's lights on top of it. The arguments are timed. They last exactly 1 hour. There's a white light that goes on when your 30 minutes has started. A yellow light goes on to warn you you have 2 minutes left. And then a red light will go on and warn you that your time is up. There's also on the inside a digital clock that ticks down. If you're in the middle of a sentence, you can ask the Chief Justice, Your Honor, may I please finish my sentence? And she can let you finish or not. At the U.S. Supreme Court, you don't have that option. If your time ends and you're in the middle of a sentence, you're out of luck. Here, they're a little more flexible with that. During the hour that you're allotted, really the justices consider it to be their time, not the attorney's time. They've already filed what's called briefs, so they've already presented their argument. The justices have read them. They know what's going to be presented. And so the justices use this time to clarify any questions that they might have. And so someone's up there giving his or her 30-minute presentation. Maybe they've just started, or they're really on a roll and they're really getting into it, and then the justices just butt in and ask them a question. They need to stop, answer the question, and be able to pick right up where they left off. So the attorneys who come here are very well practiced. They know what they're doing. Any last-minute nerves that they had, they shook them off. They left them in the attorney conference room. And so when they're here, they really have to know their arguments inside and out. They can cite cases. There's a thing called Precedent, which means that if a case had previously been heard and ruled on, the justices have to follow that. They have to keep their answer the same. And so an attorney who's here can say, you should agree with my argument because you agreed with Attorney Brown's argument in 1994, and our arguments are the same. And so if you guys see all those books up front, those are all published opinions. And so the justices can have one of their clerks open up one of those books, find the case that's being cited, and look at it and say, yes, you're right. We agreed with Brown, therefore we must agree with you. So those books are the tan books with the red and black ribbons. There's also blue books up there, which you probably can't tell from here. They're not hardbound. Those are the special acts that are passed at the legislature, and so those are constantly changing, and those are kept here to make sure that the justices are following the most recent, up-to-date version of the law. Do we have questions? Yes?
What's the most famous case that was here?
Actually, we have the National Park System is coming in August because the case of Griswold versus Connecticut, which, I wish I knew more about this now. Griswold versus Connecticut, it was a birth control issue. Planned Parenthood had taken part in it, and the state had ruled on it. The state also ruled on same-sex marriage. They ruled in favor of it before our U.S. Supreme Court did. I'm trying to think. The last case from this court that ended up at our U.S. Supreme Court was Kelo versus New London. That was an eminent domain case. That was in 2005, I believe. So there have been some landmark decisions in Connecticut. Do you have other questions? I'm trying to think what else we have. So, have you heard of the idea of being admitted to the bar? Have you guys heard that? So, after you go to college for 4 years, if you want to be a lawyer, You have to go to law school for 3 years. And then you take what's called the bar exam. It's a very difficult test. You have to study for a long time. And once you pass the bar exam, you're considered an attorney. And that allows you to pass the bar in a courtroom. This piece of wood that runs all across the room, you'll see that in any courtroom. And that's the bar. And it separates the attorneys in the case from the general public. So once you've passed the bar exam, you can physically pass the bar in a courtroom. All right. If we have any other questions?
You said the public could sit here during any case.
Yep.
Do you have to get a reservation or?
Nope, it's open to the public. Nope, we can fit, I think, about 100 people in here.
It's first come, first served?
Yep. Generally, unless it's something really contentious, generally you don't have to worry about getting a seat. And all of our cases in Connecticut, with the exception of juvenile cases and family cases, are open to the public. So where did you guys come here from today?
We live in Rocky Hill.
Rocky Hill.
Yeah, they're visiting us.
Oh, okay. So Rocky Hill, your local courthouse is New Britain. So anytime there was something going on, the lawsuit about the nursing home just took place actually in Hartford and New Britain. That was open to the public. You guys could go to any hearing. And it's the same here. It's open to the public. The last case that really kind of filled the room, there were a couple. That one would have really filled the room. But we had a case of 2 inmates who had been sentenced, I believe they were sentenced to death, and then they were sentenced to life, and they appealed their conviction here. Their names were Taylor and Gould. The main witness against them changed her mind. She decided she thought she had seen them, but really she never did. And so that was a big case. One of the men had stage 4 cancer, and so it was very important that these guys decide quickly because these men's lives were at stake. And so that filled the courtroom pretty well. I said election law comes here automatically. There was a case a couple years with Susan Beiswitz where she wanted to run for Attorney General. Someone said, you don't have the qualifications for that. And they came and argued that here. And that was pretty well filled the room. She had, as you guys see, we have chairs in front of the bar. So we have 2 sets of chairs. Generally, any argument that happens has 2 attorneys for either side. You can bring more. I don't think I've ever seen anyone just stand by him or herself. Generally, it's 2 at a time, but any other parties associated with the case would be able to come and sit up here if they were attorneys. So when Susan Beiswitz was here, it was the only time I ever saw, I think, every single one of these chairs was filled because she had a whole group of fellow politicians and attorneys with her. Anything else?
I see the camera back here.
Yes.
So you videotape these proceedings?
Certain meetings as well as certain cases are videotaped, and that's at all levels. We recently opened a pilot program that we have which allows cameras into our criminal courts to videotape proceedings. There are restrictions on it, whereas as members of the public, you guys could go into any criminal case in the state. When there is a matter of a camera, they may not go into any case. Any sexual assaults, we don't allow cameras in for. Any case involving what's called a youthful offender, someone who may end up having his or her record cleaned, we don't allow cameras in for that. So there are some restrictions. Again, that's the judge's discretion. So sometimes there's a case where it's a kidnapping of a child, and one judge will say, yes, the cameras can come in. Another judge might decide it's not okay. But the media has to request to have a camera in place. There's certain rules that they have to follow. They cannot take pictures or videos of the general public. So if you came to watch a case that day, if you were a friend of someone or just lived in the community, they would not be able to videotape you. There's certain things that we don't allow, like if a defendant is in shackles and leg irons, if they're in handcuffs, we try to not get those things taped because it makes you look guilty. It prejudices the pool against you. So there are certain rules on what they can do, but the court has made great efforts to be transparent, to do everything in the view of the public so that for anyone who doesn't come to court, they still have the opportunity to see what's gone on that day. No problem. All right. Well, if you guys don't have any more questions, I guess that's it. Thank you so much for coming. I hope you enjoy the rest of your day.